Hello, everyone. Good morning, friends. Good afternoon, everyone. Good afternoon, friends. Good afternoon, everyone. My name is Attorney Olatoyosi Asekun with the Law Office of Olu Asekun, PC, where we handle immigration cases for applicants all over the country and even outside the country. So today we are talking about the 1 year asylum application deadline, filing deadline. Today we are talking about the 1 year asylum application filing deadline. Okay. So generally under the American law, before an before a person can apply for an applicant from asylum application must be able to demonstrate that he or she is filing asylum within the 1 year of his last arrival to the US, within 1 year of his arrival to the US. But there are some situations whereby the applicant might still be eligible to file for asylum. And those exceptions are: number one, if the applicant can demonstrate that there was a change in circumstances. The applicant must be able to demonstrate that there is a change in circumstances that prevented him from filing. Then the second exception is if the applicant can also demonstrate that there's an extraordinary circumstances that prevented him or her from filing within the 1 year that he or she arrived into the US. So first, let's talk about the change circumstances. So an applicant must satisfy 3 prongs before he can be eligible for, the applicant must satisfy 3 prongs to show that there was actually a change in the circumstances. The first prong is that the applicant must show or identify the changed circumstances. The first prong, the applicant must show or identify the changed circumstances. And then the second prong is that the applicant must demonstrate that the changed circumstances affected the changed circumstances affected him, his eligibility in filing. And then the third prong is that the applicant must also demonstrate that he or she is filing within a reasonable period after the change in circumstances. The third prong again is that the applicant must establish that he or she is filing within a reasonable period after the changed circumstances. So let me give you the examples of changing circumstances. An example of that could be there is a change in the applicant's country. That is, maybe like a war is going on in the country, or that there's a change in the government that the applicant is afraid in returning back to the country because there's a change in the government that might affect, I mean, the applicant is afraid of going back to the country, basically, because he's afraid of being persecuted in his country if he returns because of the change in the government. Another example is if there's a change in applicable US law. That's another example whereby an applicant can file due to change circumstances. Then another example is if the applicant has, if there's some personal circumstances that affected the applicant from filing, maybe changes in applicant's personal circumstances while outside the country that places the applicant at risk. That's another example. Then another example could be that the applicant is a beneficiary of a previous application. Let me give you as an example of that. An example could be that somebody had actually initially filed an application, an asylum application, whereby this new applicant was a beneficiary under the existing application, under the existing asylum application. It could be that the person, this new applicant, was married to the former applicant that applied. And now maybe they are not together again. And now the applicant now wants to file. That's an example of a change circumstances. Another example could be that the applicant is still is a child of the main applicant, but now the child, he or she has now aged out. Maybe he or she is over 21 years old now. So the applicants can still file based on that. Then another example could be that the applicant had a legal disability at that time. It could be that, okay, the applicant was still a minor at that time, or that he was mentally impaired. That's another example of changed circumstances. Now, so in establishing, okay, I think I already talked about it. Let me talk about it if I can't remember if I talked about it earlier. So in showing changed circumstances, the applicant must be able to identify or show the existence of a changed circumstances. The applicant must be able to demonstrate that the changed circumstances is material to the applicant's eligibility for asylum. That's the second prong. And then the third prong is that the applicant must establish that he is filing this application within a reasonable time after the changed circumstances. That is for the exception of changed circumstances. Now, let me talk about the exception of extraordinary circumstances. This is when there is an extraordinary circumstance that directly delay the applicant's eligibility to file during the 1-year deadline. Again, extraordinary circumstances that can make an applicant file after the 1-year deadline is when there is an extraordinary circumstances that directly affect the applicant's eligibility to file within the initial 1-year deadline. And also, this also has 3-prong test. The first prong test, the first prong is for the applicant to identify and show that there is a extraordinary circumstance that delayed him or her from filing during the 1-year deadline. Also, the applicant must show that the extraordinary circumstance directly affects is his or her own eligibility to file. Now, the third prong is that the applicant must establish that he or she is filing within a reasonable period after the extraordinary circumstances. So let me give you the examples of extraordinary circumstances that could have affected the person. So the first example is if the applicant had a serious physical or mental illness during the 1 year deadline. An example could be that the applicant had a serious mental or physical illness during the 1 year deadline. Another example could be that the applicant's representative or attorney was either sick or died or something happened during the 1 year deadline. Maybe the applicant had already visited the attorney and they had already both discussed about it and paid, and the applicant had told the attorney or the representative had told the attorney that, told the applicant that he was going to go ahead and submit the application, and something happened to the representative or the attorney. So, and that was what caused the delay in applying. So this is also an extraordinary circumstances. Another example could be that the applicant had earlier filed within the 1 year deadline, but there was some technical issues. It could be that maybe the application was not well filed and USCIS rejected it and sent it back to the applicant. So, and the applicant had to make corrections and file. So if that applicant files within a reasonable time, that could also be an extraordinary circumstances. Then another one could be that the applicant had a temporary protective status before, or the applicant was in legal immigrant or non-immigrant status before. So that could also be an example of extraordinary circumstances. So those are the examples, those are the exceptions for filing after the 1 year deadline. So I'm available. If you have any questions, you can send in your questions and then we'll be able to answer. Okay, give me a little break. Let me go on a short break. I'll be back. Thank you. Hello, hello everyone. Yes, we are back from the break. Yes, okay. So we are talking about the 1 year deadline, filing deadline for asylum application. That's the topic for today. Let me quickly give you a recap of what I said earlier on. So earlier on, I said that typically the U.S. law that for someone to apply for an asylum, you will have to the applicant must establish that he or she has filed within 1 year of his last entry into the United States. The person must establish to the USCIS that he or she is filing the asylum within 1 year that he or she came into the US. But there are some situations whereby an applicant can still file for asylum after the 1 year deadline. Now, let me quickly talk about something. This 1 year deadline is only for asylum application. It does not include withholding or withholding or CAT. It doesn't include both. It only includes it is only applicable to asylum application. Now, there are some situations, there are two exceptions whereby a person can apply after the 1 year deadline. The first one is there is a change in circumstances. Example of changes in circumstances could be that there is changes in the applicant's country. Maybe there is a war going on there, or maybe there is a change in government, and the applicant is afraid that if he goes back to his or her home country, he might be persecuted. And also, it could be changes in the applicant's personal circumstances while outside the country that places the applicant at risk. That's also an example. Another example could be that the applicant was somebody had previously filed an asylum application whereby the applicant was a beneficiary of that application. For example, if the applicant was previously married to the person that applied the initial application, and now they are divorced, so the applicant can decide to file by herself, by him or herself. Or it could also be that the applicant happens to be a child that was included in the previous application, but now the child has aged out. Maybe the child is over 21, so the applicant can file. That's an example of changed circumstances. It could also be that the applicant had a legal disability. That is to say, the applicant at that time was a minor, or he had like a mental disability. It could also be an ineffective assistance of counsel, even though there was a case that we handled that the judge still said this judge still didn't agree with that. It didn't see that as an exception. So, and in establishing that, there are 3 prongs. The first prong is that the applicants must show or identify that there is a changed circumstances. Also, the applicant must demonstrate that the changed circumstances is material to his or her own eligibility for asylum. And then the third prong is that the applicant must demonstrate that he is filing the application within a reasonable time or period after the changed circumstances. Okay, so now talking about the extraordinary circumstances. This is when there is an extraordinary circumstance that directly affects the delay of the applicant or that directly affects the applicant's eligibility in filing the asylum. So there's also a three-pronged test to it. The first one is for the applicant to identify the extraordinary or show the extraordinary circumstances that delayed him from filing. And then he must also demonstrate that the extraordinary circumstances, he must demonstrate that it affected him personally. And then also establish, the third prong is that he must establish that he or she is applying for the asylum within a reasonable period after the extraordinary circumstances. Also, example of extraordinary circumstances could be that there was a serious illness. It could be physical or mentally, that the applicant had a serious illness, physical or mentally, during the 1-year deadline. It could also be that the applicant's representative or attorney was probably sick or died or something. It could also be that the applicant had a temporary protective status or immigrant or non-immigrant status during that period. And it could also be that another example could also be that the applicant actually filed within the 1-year period, but there was a kind of technicality, maybe like a problem with the filing, that the USCIS had to return it, and the applicant refiled after making the correction within a reasonable period. So that's it. Those are examples of extraordinary circumstances. So bring the questions. Listening. Okay. So this is a question. Hello, ma. What types of questions are usually asked at an asylum interview? And how can you go? And can you go over what typically happens at the asylum interview? Well, sir or ma, the kind of questions, usually when you are filing your asylum application, you would have written a statement, and then you have to have given them the reason. There's a form that they will ask you to take the reason for the asylum. It could be for that you're seeking protection because of persecution for either race. It could be because of religious. It could be due to political or social group. So they are different. So it depends on why you are filing for the application. So the questions are typically going to be based on whatever you have written in your statement. If you are filing application due to a social group, maybe you're afraid of FGM. Maybe you actually said that maybe you are married and you had previously been mutilated. FGM have previously been performed on you, and you're afraid that you're afraid for your child, your daughter. So, and whatever you say, the questions is going to be based on your personal statement. Those are the kind of questions. They could ask you, okay, in your statement, you said that so happened at a time. So the questions are just going to be based on whatever you wrote in your statement. That's it. Keep the question coming. Bring in the questions. So we are talking about the 1-year asylum application deadline today. We said there are exceptions, and those exceptions could be maybe there is a change in circumstances, or there's an extraordinary circumstances that prevented you from filing during the 1-year period. An example of change in circumstances could be change in your country. Changes in your country, it could be maybe there is a war that happened that's happening in your country and you're afraid of going back. Or it could be that there's a US law. There's an applicable US law that might benefit you. It could also be that at that time you filed, you had this legal disability. Either you could have been a minor at that time, or that you were mentally impaired during that period. You could also be an ineffective assistant of counsel, even though sometimes the judges don't agree with that. And then there's also an exception of extraordinary circumstances, which could be that an example of that could be that at that time you were seriously sick, physically or mentally. It could be that your attorney was sick too or died or something happened during that period that prevented you from filing. Also, it could be that you had a TPS or you were in lawful immigrant or non-immigrant status at that time. Or it could also be that you filed within a year and it wasn't properly filed and the USCIS had to reject it and you had to refile after making the correction within a reasonable period. So keep the question coming. Oh, okay. This is another question. It says, what is the difference between asylee status and refugee status? Okay. Okay. So filing an asylee status is when you already in the US, you're already in the US and you want to file for asylum. That is asylee status. But refugee status is if you are being persecuted or something happened. I'm sorry about that. Yeah, if you are being persecuted in your home country, or something happened and you are still outside the US and you apply for asylum, that is the difference. Asylee status, you are in the US. Refugee status, you are outside the US. That's the difference. Okay, another question is, can you work while waiting on your asylum application? This is a good question. Well, before you can even work in the US, you have to have an employment authorization. Just mere filing does not indicate that you are eligible to start working. It's just you're just still waiting for the benefit, for the government to give you the benefit. But there are some situations where you can work, but before you can work, you still have to get the employment authorization anyways. But after you are filed, after you are filed and you have not been called for interview, you have to wait. Before you even work, you also have to get your social security card too. And then you can also use your employment AAD, that's the employment authorization card, to get an ID or social security number. So before you can work, you need all those things. Now, after you are filed, you have to wait for 180 days before you can apply for an employment authorization. If you are filed and you have not, you can apply for an employment authorization within 180 days. You can file before you can get an employment authorization. Keep the question coming. Keep it coming. Okay. Okay. So also, um, if you file, it makes if you file for an employment authorization, there's this membership that is called ASAP. It's just a membership. It doesn't guarantee just being a member of that ASAP doesn't guarantee that your asylum is going to be approved. It's just a membership that make them approve your employment authorization within 60 days. It just makes it faster. It is not that because you are a member of the ASAP that your asylum application will be approved. No, the purpose of that is just to make them, I mean, so that your employment authorization will be done fast. And typically, if you join that membership, you can get your employment authorization within 60 days. This is not guaranteed that it's fast, but it's just that it's helpful. And that also for asylum application, you do not even have to pay for biometrics. It does not mean that you have to pay. You don't have to pay for biometrics when you join the ASAP membership. Keep the question rolling. I'm here. Keep the question. Send in your questions. This is free consultation. Typically, if you're trying to find information, you have to pay your consultation fees, but this is just free information. And then please share this program. Don't be selfish about it. Share it to your friends, family. We are not doing it for any purpose. We are just doing it so that people can benefit from this. You can know your rights. There are a lot of people, like I had a client yesterday that she had previously filed different applications. She filed an I-130 that was denied. Later, she switched to VAWA I-360. It was denied. And now she's on appeal. And then she came to our office and wanted to know that if it's possible for her to, because she said she's afraid, she doesn't know what the outcome is, and that because she wants to retain her application and her employment authorization. So she consulted if she could switch to asylum after 7 years in the US. So this is something that, a lot of people, because there's news all over. Some people are like, oh, once you apply, you can apply at any time. You can apply for asylum application anytime, and it's not going to affect you. But that's a big lie. So that's why we are doing this. We are doing this so that people can have information, people can know their rights, people can. That's why we are doing this. So don't be selfish about this. Share. Let people know about what we are doing. Okay, there's another question. The question says, if someone files for asylum, but then gets married to a US citizen, what can you do? If someone files for asylum, but then gets married to a US citizen, what can you do? Well, the first thing that I want you people to know is that in filing for asylum application, if the USCIS determine that you have filed a frivolous asylum application, that is a permanent bar. Permanent bar. It's not going to, you will not be able to apply for any other immigration benefits. The first thing I want you guys to know, because there are a lot of people just filing different kind of frivolous application. If the USCIS can determine that you have filed a frivolous application, it's going to be a permanent bar. for any other immigration benefit. Now, talking about the question that if someone files for asylum and gets married to a US citizen, what can you do? Of course, anybody can fall in love with a US citizen and get married to the person. But I don't know, it depends. If like I said earlier, most important thing, USCIS must not determine that your previous application, that your asylum application is a frivolous application. If it is determined, it's going to be a permanent bar. Even if you marry the the US president, you will not be able to get any immigration benefit, any other immigration benefit. But if that has not been determined, yes, you can, everybody is free to marry anybody. So, and one of the benefits of being a US citizen is to be able to file for your spouse. So, if you get married to a US citizen after you have filed your asylum application, the US citizen can still go ahead and file an I-130 for you. And then you can withdraw the asylum application. After all, it's a better alternative. It's easier for you to get your green card faster, because even if your asylum application is granted, you still have to wait for a year before you get your green card. So this is a better alternative. Keep the question rolling in and share. Please share. Let everybody benefit from this. You're not paying for this consultation. You know how much you will pay if you come to our office. Keep the question rolling. Keep the question rolling. Keep the question rolling. Just share with your friends, family. Let other people benefit from this. Share, please. Okay. Yeah. Like I said earlier on, before you file for asylum, think about it. Don't file frivolous application. Because if the USCIS determine that you have filed a frivolous application, it's going to be a permanent bar for you from applying for any other immigration benefits. If you have the form with you, you can Google it. Go to USCIS and you can Google it. Yeah. Google go the forms and then go to page 9 on it. It is written there in bold. It is written there that if you file a frivolous asylum application, that it could permanently bar you from applying from any other immigration benefit. So before you file any asylum application, think about it. Don't just go and join people, because there are a lot of people that are like, oh, let's look for one story and tell them, and so that I can be able to get my employment authorization. So think about it very well before you apply. Also, so this 1 year filing deadline applies to affirmative asylum, because there are two types of asylum. There's the affirmative asylum, and then there's the defensive asylum. The affirmative one is the one that you file with USCIS asking for asylum. That's the one that you file with USCIS. But the defensive asylum application is the one that you file with EOIR. That's with, I'm sorry, I take that back. You don't file that. When you don't file when you can file it, but before that can be done, you have to be in removal proceedings before that can be done. So that is defensive asylum. That's the difference. There's a difference between affirmative asylum application or defensive asylum application. For the affirmative one, that has to be filed with USCIS. But for the defensive one, that is done, when you are in removal proceedings and, you're trying to find like a relief why you should not be deported. So you could file a defensive asylum application. Okay, this is another question. The question is, what happens after my asylum case is approved by the asylum officer? This is a good question. What happens after my asylum case is approved by the asylum officer? Good. After your asylum is approved, you are not granted the asylee status. You are granted the asylee status when your asylum application has been approved. I know that a lot of people, some people feel that they are asylees once they had applied, even without their asylum status application granted. A lot of people feel that once they have applied, that they are asylees. No, you are not an asylee until your asylum status is granted. Also, when your asylum asylum case is approved, then after a year, you're eligible to apply for your adjustment of status. After a year, you are eligible to get your green card. You get your green card after a year. Get your green card after a year that your asylum application has been approved. So another question. May I file for asylum if I'm out of status? May I file for asylum if I'm out of status? Yes. You can file for asylum if you're out of status. But the thing is just that you have to try to prevent any you have to be able to file within 1 year. But you can file even if you're out of status. The only thing that requires is your physical presence in the US. That is the only required. You have to be physically present in the US to apply for asylum status here. And a person who is out of status may obtain legal status if granted asylum. Yes. If you are granted asylum, you can still obtain legal status. You can obtain it. The only thing is that if you're out of status, your asylum will be. If your asylum is denied, you're going to be put in. No, not denied, because USCIS do not have the jurisdiction to deny an asylum application. The only thing is that they can either approve, and if they don't approve, they will issue a notice to appear, an NTA, and you have to go to the immigration court. So you'll be put in removal proceedings if you apply, whether or not you are still in lawful status. If you apply and I take that back. If you are out of legal status and you apply and your application is denied, you'll be issued an NTA and you'll be put in removal proceedings. Another question is, what kind of information is required in an asylum application? What kind of asylum is what kind of information is? I'm sorry, I'm squeezing my face. I'm not wearing my glasses. That's why. That's why it's kind of hard for me to read that. What kind of information is required for an asylum application? Well, in addition to the actual application, asylum application, the form that you fill, for you to have a successful asylum, if you want your asylum application to be approved, you have to submit other documents, maybe, documentary evidence, supporting documentation. It could be newspaper publication, statement from country experts, statement from people, maybe police reports. It could also be report from government and human rights organization, affidavit from family and friends, and from friends. Anything that could support your case, then with your statement, because an asylum application is time consuming. So one of the things that we do is that we tell you, once you're applying, gather all your documents. Sometimes, but most of the time when you're applying, try as much as possible to gather enough evidence that will convince the USCIS officer about your case. But before you apply, I recommend, before you apply for asylum, because it's a lot of people feel it's something that they can just do by themselves. But I'll just recommend that you contact an experienced immigration attorney that will help you, and that has to be done within a 1 year that you get to this country. We are available to help. We are available. We attend to immigration cases from all over the country, not only in Dallas, not only in Texas. We could go anywhere. We can file for you anywhere. We can help you anywhere in the country. We can do that even outside the country. So if you don't have any attorney that can help, we are available to help. Our office is located at 5020 Mansfield Road, Arlington, Texas. Again, 5020 Mansfield Road, Arlington, Texas. If you want our phone number is 817-274-1144. I'm sorry, let me get the phone numbers. Okay, another question. May I leave the country after I have submitted my asylum application? If you leave the country after you have submitted your asylum application, it is presumed that you have abandoned your application for asylum. So you can't leave the country after filing. It is not advisable for you to leave the country after filing for your asylum application, because it will be presumed that you have abandoned your your application for asylum or withholding of deportation. Okay, so I was saying before, you can contact our office at 5020 Mansfield Road, Arlington, Texas, zip code 76017. Our phone numbers to are 817-983-4499. That's the cell phone number. Another cell phone number is 817-891-6655. 817-883-4495. We are available for Zoom meetings. We can call, we can do video call, video chats. You can call our office, or you can come in person. So we are available to help you for all your immigration needs. Not only immigration, we also do personal injury, family law, but we are talking about immigration right now. So we can help. Okay, another question. If I have had an asylum application denied in the past, can I still apply for asylum? If I had an asylum application denied in the past, can I still apply for asylum? Well, possibly. A prior denial is a basis to deny a new asylum application only if the denial is from an immigration court or from BIA, that is the Board of Immigration Appeal. So, if your application claim was denied by an asylum officer and you were simply returned to your legal... What's the question again? If I have an asylum application denied in the past, can I still apply for asylum? Yes, you can still do that. Keep the question rolling. Don't be selfish about this. Share. Let your friends know about it. Let everybody knows about it. Don't keep this information to yourself. We are only doing this. We are not asking for any consultation fee. You know, if you need to consult us or any other attorney, you have to pay. But this is like free consultation. So share. Let your friends, family, let everybody, let them benefit from this. We are not doing it for any benefit. I mean, our only benefit is just to educate people. We are not doing it for any financial gain. So the best you can do for us is to share. Keep the question rolling. Okay. Is there a fee to file for asylum? No. There's no filing fee to asylum. But, if you have to file and you're using an attorney, you have to pay for the professional fees. You have to pay the attorney's professional fees. But for the filing fee, no, you don't have to pay. It's free. Keep the question rolling. Keep the question rolling. Share. Don't be selfish about this. Share. Tell your friends, family, we are available every Wednesday, 12 o'clock Central Time. We are available. Keep the question rolling. Keep it rolling. You have to file within 1 year of you getting to the US for asylum. That's what the law says, but there are some exceptions. And the exceptions are if there is a change in circumstances or there is an extraordinary there's a change in circumstances or extraordinary circumstances that delayed you from filing within the 1 year deadline. Those are the exceptions. And examples of changed circumstances are changes in the applicant's country. Maybe there's a war that's preventing you from going back to your country. Or maybe there's a change in government that you are afraid that if you go back to your country, you may be persecuted. That's an example of changed circumstances. Or it could also be that somebody had previously filed for you, and maybe you used to be married to the person that had applied for you that you were a beneficiary, but now you are divorced. That can also be you can also file because of that changed circumstances, or as a child you have aged out from a previous application. Yeah, that's also. Another example is if you have a legal disability, that is, if you are still a minor. If you were a minor at that time, or you were mentally impaired at that time. And then examples of extraordinary circumstances could be that at that time, the 1 year deadline, you were probably sick, either physically or mentally, or someone close to you, maybe your immediate relative, could be your spouse, your child, or somebody close to you. Your immediate family is your child, your spouse, your parents. So if anything, God forbid, anything happened, maybe somebody died and that prevented you, or God forbid, somebody had a serious illness, that could also be a ground for you to file after the 1 year. Keep the question rolling. Keep the question rolling and share. We are available every Wednesday, 12 o'clock Central Time. Available 12 o'clock. Keep the question rolling in and share. Don't be selfish about this. Share to your friends and family. So, also, when you are filing for asylum, waiting. What's this question? Yeah, I know a lot of people. Some people apply for asylum based on personal reasons. Some people had approached us and asked if um, maybe can they file for asylum just because in my country I was married and my husband is abusive. Can I file for asylum? That's not a grant for asylum. You cannot file. You cannot come to the US and file for asylum just because your husband was abusive to you in your country, your home country. That's not a basis for asylum. For you to file for asylum, you must have a fair. It must be based on the fact that what's this question again? So the question was, please share this program. Don't be selfish about it. Okay, the question is, there is a lot of kidnapping going on in my country. Can I apply for asylum? there's a lot of kidnapping going on in your country. Can you apply for asylum? No. You cannot apply for asylum based on the fact that there are lots of kidnapping going on in your country. Because there's a reason why you have a government in your country. America cannot, your country, America cannot just go to another country. It's like you have, your country is sovereign. You can't just go there and start interfering in other people's business. So if there is a lot of kidnapping happening in your country, sure, your government should do something, will be able to do something about it. There's the police. You can always report to the police or some other, but America will not give you asylum just because there are lots of kidnapping going on in your country. No. But if your government cannot do anything about it, and you are specifically targeted, it could be that, and it has to be that the maybe the person that is, the person that kidnapped you is someone that the government does not want to stop, or is something that the government cannot stop. Well, and you are targeted, that could be a basis for you applying, but not that somebody there are lots of kidnapping going on. No, that's not a basis for asylum in your country. Keep the question rolling. Keep them rolling. And please share. Share with your friends, family. We're trying to let people know their chances. Trying to educate people, because there are a lot of people out there thinking they can file asylum at any time once they are here. Some people spend 5, 6, 7 years, 10 years, and think that, okay, now maybe after filing other applications that have been denied, now think, okay, what's the next thing? At least I still want to be having my employment authorization. So we're just trying to let people know that there's a time limit. There's a 1-year deadline to apply, to filing for asylum. Okay, so keep the question rolling, because if you don't have if there are no more questions, then I won't be motivated to continue talking. Keep the question rolling. Again, today's topic is the 1-year deadline asylum application deadline. That's today's topic. And like I said earlier on, an asylum applicant must demonstrate that he or she is applying within the last 1 year, within 1 year of his last arrival to the country. Before you can apply for asylum, you have to demonstrate that you are applying within 1 year of your last arrival to the country. But there are some circumstances whereby there are exceptions. And those exceptions are if there's an existence of changed circumstances, or there are extraordinary circumstances that prevented you from filing within that 1-year deadline, then you can file. You can apply. You might be eligible to file for asylum. And talking about the changed circumstances, you have to show and identify the changed circumstances, and then you have to another prong that you have to satisfy is how the changed circumstances affected you, and you have to also establish that you are filing this asylum application within a reasonable period after the changed circumstances. Example of changed circumstances could be that there are changes in your country that's preventing you from going back to your country. It could be that there's a war going on in your country, and that's based on that you can't go back to your country. That's an exception. It could also be that maybe there's a change in government and that you are afraid that if you go back to your country, you might be persecuted based on your nationality, religion, membership in a particular social group, or any other thing. It could also be that someone had previously applied for you. When you were just a beneficiary in the initial application, it could also be that. And now, it could be, for example, your spouse had initially filed for you, but now you are divorced. So you can apply on your own. That's an example of changed circumstances. You could also be a child that was filed for, but now you have aged out. That's another example. It could also be that um, you had a legal disability at that time. Maybe you were just a minor, or you were mentally impaired at that time. It could also be for ineffective assistance of counsel, even though we had a case that the judge said that's not enough reason. So now, talking about the extraordinary circumstances, also you have to satisfy 3 prongs. The first one is that you have to identify and show the extraordinary circumstances that prevented you from filing within that 1-year period. And then the second prong is that you have to demonstrate how it relates to your eligibility of filing within 1 year. And then the third prong too is that you must establish or demonstrate that you are filing within a reasonable period after the change in circumstances, in extraordinary circumstances. An example of extraordinary circumstances could be maybe sickness, serious illness, or serious physical or mental illness. That's an example of extraordinary circumstances. It could also be that you had a representative or an attorney that you had actually paid for, that was supposed to help you within that 1-year period, and something happened to the person. It could be that the person, maybe the attorney or the representative, fell sick or died or something. That's also an extraordinary circumstances. Or it could also be that you previously had a temporary protective status, or you previously have an immigrant or non-immigrant status. Or it could also be that you actually filed within 1 year with USCIS, and that application was technically sent back, technically rejected, because maybe probably you didn't fill the form, the correct version. Maybe there's a new something that happened technically. So you can do that. You can apply within a reasonable period. Oh, okay, there's another question. Let's see. My parent file for- If my parents, I'm sorry, next time I'll bring my glasses. If my parents, oh, okay. Another question is, if my parent filed for asylum but it was denied, and I'm now a minor, when they apply. Now I'm over 21. Can I apply for asylum? If my parents, I'm trying to figure out these questions. It's not straight. It's not. If my parent filed for asylum but denied, are you trying to say that if your parent filed for asylum and the asylum application was denied, and you are a minor when they apply? Oh, okay. Are you trying to say that if your parents apply for asylum but the application got denied, and at that time you were a minor, and now you are over 21, can you apply for asylum? Well, I mean, like I said earlier on, if at the time your parents applied, you were still a minor, yes, you can. That's an exception. Yeah, that's an exception of an extraordinary circumstance. So you can file, but I mean, like I said earlier on, it must not be determined that you are filed a frivolous that your application is a frivolous application. So I mean, if your parents filed at that time and it was denied, I don't know why it's denied. I don't know why it's denied, but if it's the same reason, they might not approve it. Well, I don't know if you have another, it might be based on another reason, Who knows? You can apply. But if it's still based on that reason alone, USCIS might not approve it. But yes, you can file. You can file if your parents had previously included you in a previous application and at that time you were still a minor. You can file. But if it's still based on that same reason, it might not be approved. So any question? Or we call it a day. So we'll be calling it a day. But like I said earlier on, we are available every Wednesdays. Share this program with your friends. So we are available every Wednesday. Also, the RCCG convention on Friday, June 16th. We are going to be there live with the whole office. Dr. Olu will be there. Dr. Olu will be available. I will be there. Marisa will be there. Kim will be there. So if you have questions, you can come, but we'll be there live. Thank you all. Thank you for this podcast. Thank you. Bye.